Good morning, bonjour, buenos dias, or buenas tardes, depending on where you might be. Thank you very much for connecting to this webinar hosted by the Human Rights Research and Education Center of the University of Ottawa. My name is Salvador Herencia, and it is my great pleasure to welcome all of you for this webinar where we are discussing a very important and very timely topic regarding the participation or under participation of women in the judiciary and prosecutorial offices around the world. It is today we have the pleasure of having my colleague Mr. Jordi Feo Valero and the UN Special Rapporteur for the Independence of Judges Diego Garcia Sayan and Professor Hélène Trigruja from the University Aix-Marseille and also member of the UN Human Rights Committee. It is once again, thank you very much for being here with us. And I would like to now give the floor to my colleague Jordi. Jordi, por favor.
Hello, everyone. Bonjour. Good morning, ladies and gentlemen. Thank you very much for being here today. My name is Jordi Feo, and I work as fellow at the Human Rights Research and Education Center of the University of Ottawa, where I coordinate the project on the UN Special Rapporteur on the Independence of Judges and Lawyers. It is an honor to moderate this webinar, during which we will analyze the participation of women in the judiciary and prosecutorial offices through two presentations. As you know, the Special Rapporteur of the Independence of Judges and Lawyers, Mr. Diego Garcia Sayan, presented in July his sixth report to the General Assembly. In the report, the Special Rapporteur focused on gender equality in the judiciary. The report examined the current status of women representation in judicial systems, identifying the barriers hindering their adequate access to and promotion or retention in the judiciary and prosecution services. Without further delay, please allow me to introduce our panelists this morning. Today, we are pleased to welcome Mr. Diego Garcia Sayan, the UN Special Rapporteur on the Independence of Judges and Lawyers, and Mrs. Hélène Trigruja, expert at the Human Rights Committee. As you know, the Human Rights Committee is the body of independent experts that monitors the implementation of the International Covenant on Civil and Political Rights by the States Party. Mr. Diego Garcia Sayan, you have the floor, please. Thank you very much.
Thank you, Jordi. Merci beaucoup. Bonjour. Good morning. Good afternoon. And it's really an honor and a pleasure to be to having been invited to this panel, in which I feel very closely connected to the Human Rights Clinic in the Ottawa University, in which Salvador and Jordi have given to the task of the Special Rapporteur a fantastic and extraordinary support in the last years, substantial, I would say. So to achieve certain results that wouldn't be possible without this great and fantastic support. So honored to be part of this panel, to share the panel with Salvador Herencia. And of course, it's a pleasure to meet Professor Hélène Trigruja, which is, I guess, there in Marseille, and very honored to be with a colleague which is part of the UN system as well, in which we have, I'm sure, the same goals, the same dreams, and perhaps the same constraints in the always complex UN system. So what I'm going to share with you today is not a discovery of America. but just certain key concepts and aspects that I have mentioned, and as Jordi has recalled in my last report to the General Assembly presented approximately 1 month ago. In the report, I examined the current status of women's presence in judicial systems, identifying the main barriers to women's adequate access, promotion, and retention in the judiciary and prosecution services, especially in its high levels. The report focuses on the urgency of generating conditions for women's access to the judiciary and the prosecution service to encourage effective and not just discursive gender equality in the system of administration of justice. To prepare this report, identify the main challenges to make gender equality effective in the judicial system, especially at the highest level. I circulated a questionnaire asking for contributions from states, NGOs, international organizations, which receive fantastic amount and quality of responses. As well, we organize regional meetings with women judges in Europe, Latin America, USA, Canada, and Africa, in which we receive an amazing level and quality of coincidences in the concerns and challenges faced by women judges in different regions of the world, which apparently have completely different situations and conditions than Scandinavian countries or Latin American countries, for instance, which seem to be so different. There are a lot of similitudes in the main challenges and threats against women's participation. The core finding of the report is very clear and fundamental. Gender equality in the administration of justice continues to be more a discourse rather than a reality. Despite international campaigns, discrimination against women in judicial system persists. The data collected show, however, that the general trend in recent years has been a gradual increase in the number and proportion of women in the judiciary and the prosecution service in their lower and intermediate levels. In some countries, women even outnumber men in terms of the number of judges and prosecutors. Europe leads the way with 54% women, followed by the Americas with 51%. This data, of course, contrasts with those of Oceania, 31%, Africa, 30%, and Asia, 29%. However, there are three main points of concern from the data obtained. Firstly, that as one moves up in the career ladder, the number of women in managerial or senior positions is decreasing considerably, this being a consistent trend globally. For instance, Supreme Courts, constitutional tribunals, or prosecutor generals. This is a generalized tendency in the world with very few exceptions. Second, the fact that gender prejudices and stereotypes continue to affect women, especially in terms of assignments. Women are assigned, for instance, to certain jurisdictions simply because they are considered better suited to women's courts, such as family labor or peace courts. This is as well a generalized tendency. And third, the conditions of work and promotion within the judicial and prosecutorial careers tend to have a differentiated impact on women with lower economic capacity or who have to combine their work activity with their lifestyle and family responsibilities, which is the case of the majority of women working in the judiciary. This is a case, for instance, with the requirements of higher education beyond a bachelor's degree or special additional training courses for promotion that require economic resources and more time outside besides working hours. All this puts women in a disadvantageous position. The problem thus lies in consequence in the unequal or scarce implementation of appropriate measures by the states, which have to do not only with the justice system, but with the institutions as a whole. There are well-known barriers which led to underrepresentation in high-level public decision-making functions, not only in the judiciary, or its confinement to certain areas of the judicial system. The lack or weakness of explicit and sustained public policies in this area within the state in charge of promoting them harms the judicial or prosecutorial service for an equal presence of women. From all the consultations carried out with groups of women judges in different regions, among other obstacles, it is clear that the absence of public policies aimed at supporting the reduction of family burdens is another of the main obstacles to the promotion of women judges. This is one of the circumstances that affect really the increasing participation of women. As I state in my report, there is a greater risk for women judges and prosecutors as well to suffer internally aggression or different forms of harassment in the workplace, the so-called sextortion, as the International Association of Women Judges has called it. Gender stereotypes facilitate the harassment and violation of the personal integrity of female judges, taking advantage of the anonymity provided by new technologies and on occasions with the connivance of a public opinion that is mostly dominated by men. Regardless of the region in which they are located, female judges have reported in all of the regions being victims of workplace or sexual harassment at some points in their careers. Nevertheless, I must acknowledge the efforts made in several countries to correct the effects of these stereotypes in the judicial system. It has been possible to identify the adoption of different measures, such as training programs in gender perspective or the inclusion of the gender perspective in law schools. The limited presence of women in high courts and leadership positions is a major and generalized pattern at the global levels. Even in those countries where there is equal representation of the sexes in different courts, as one moves in the ladder of power, the percentage of women decreases dramatically. This reality must be transformed. It violates human rights. I have made a public call to all countries at the General Assembly to dismantle the so-called glass ceiling, that invisible but insurmountable barrier that prevents minorities and women from ascending to the top ranks of the judicial system. Urgent measures are needed to ensure equal conditions for access to higher courts so that equal career advancement is achieved. When I presented this report at the General Assembly, I received an amazing degree of support by the member states, European Union, several African Asian countries, United States, Russia, China, in a consistent way, which in a way has a special meaning for me to follow up then if that support is consistent, what measures then will be taken, not only by the countries that spoke, but the others that were present as well and follow the presentation. Among the various recommendations which my report concludes that received this public and general support, I would like the following 7, and with this conclude my presentation, my introduction. First, perhaps the most relevant of these recommendations. Within the framework of the Sustainable Development Goals, every effort should be made to ensure that by 2030, 50% of senior positions in the judiciary and the prosecution service are held by women. This is a crucial point to have a precise goal and not a general concept that doesn't lead to specific public policies. Second, design and implement a quota system that is not merely symbolic to ensure equality in entry to positions in the administration of justice and to achieve greater quality from a geographical or regional perspective. This quotas procedure could be debated. There was one country that expressed disagreement with the procedure, Russia, in the presentation in the General Assembly. They said there will be other ways to achieve this goal. I responded, okay, if there are different ways to achieve that result, perhaps a quota system wouldn't be necessary. But I just want to recall right now a recent example of the positive impact of a quota system, which is the recent appointment in Mexico of a women judge this week to the Supreme Court, which is a very important court in Latin America, in that country, in which the Constitution establishes equality within men and women in the high courts. So in actual context in which there are only 3 women among 11 members of the Supreme Court, the 4th one has just been appointed in a selection process in which an effective priority, fortunately, was given to women. So concrete steps can be taken following specific institutional and political decisions. Third, create, where need does not exist, a public, autonomous, and independent institution that coordinates the policies on equality and gender perspective and its compliance by all public entities, adopting for this purpose norms, public policies, and quantifiable goals. So it means that if we are dealing with a paritarian presence in judicial bodies, we need that to be part of a general public policy, so not have this kind of exceptions in the judicial bodies. And this will strengthen, of course, specific policies inside the judicial system. Fourth, review the formal requirements for entry or promotion in the judicial career, so that the glass ceiling does not persist and there are no bureaucratic barriers that hinders women's access to high positions in the judiciary. To this end, it is recommended that competitions be held specifically for women, at least during the certain phase on time, especially when the courts are composed only of men or when there is a higher percentage of female judges that has not been possible to access to higher courts. Fifth, eliminate the stereotypes that pigeonhole women in specific areas of law or at certain levels in the judicial hierarchy, such as family law or at the lowest levels of the judiciary, peace courts or provisional courts, with no guarantees of employment or tenure. Six, encourage the strengthening and, where appropriate, the creation of association of women judges and prosecutors that strengthen the participation of women in the judicial and prosecutorial careers, defend their rights, and enable them to participate in the adoption of policies to promote gender equity in the judiciary and the prosecution. And seven, the gender perspective must be assumed as a fundamental articulating criterion, as well as a method of reasoning and objective and rigorous analysis that identifies, eradicates the gender stereotypes that plague the courts and prosecutors' offices, and that assumes the gender perspective as an inescapable duty of the state. So these are a selection of the recommendation in a context, as I was saying, in which I understand the debate that followed my presentation in the General Assembly with a big support by the countries present. So my understanding is that that support that was on the record must and should be used to follow up these recommendations that have specific standards fixed, so that in the following years, coming from now to 2030, which are not too much, we can begin to ask all the countries what they have done to improve this situation. And that, I would say, this is not a matter only of this special rapporteur with very few scarce or null institutional bureaucratic support in some conditions, but of all the actors connected with human rights, not only in intergovernmental organizations, but of course organizations like the Clinic of Human Rights, universities, and so on. So I appreciate the invitation, Jordi, Salvador, to share with you, and I will be really pleased to hear the presentations from Professor Elenti Gruda and of Salvador Herencia now. Thank you very much.
Thank you very much, Mr. García Sayán, for your presentation. Now I give the floor to Madame Ticourja. Madame Ticourja, you have the floor. Thank you.
Thank you. Thank you very much for the invitation. Thanks to the Human Rights Clinic of the University of Ottawa. I'm really pleased to share this panel with Diego García Sayán. And I really want to, at the outset of this presentation, to to thank him for his reports in general. They are extremely important, not only for civil society, but also for treaty bodies. And very recently, in a decision the Human Rights Committee adopted versus Spain, so the decision Garson versus Spain, we used one of your report, Diego. So for us, it's not only, we use the report especially to interpret Article 14, the right to a fair trial, the right to independence, and what independence tribunal, impartial tribunal means in a democratic society. So for us, it's really also a source of interpretation, this kind of report when they are, especially as this one of extremely high quality, it's important for treaty bodies. So I'm really pleased and honored also to share this panel with you and to have the opportunity to pay this tribute to your wonderful work. And we know that in different parts of the world, judicial independence is really under attack. So thank you very much for having me. Maybe I would like just to begin with a remark that was made by one of a former judge of the European Court of Human Rights, a female judge. And we invited her for a conference in Aix-en-Provence. And she told us that she never felt as discriminated against as when she was member of the Human Rights, of the European Court of Human Rights. And we were surprised, of course, because the European Court of Human Rights is supposed to be a human rights tribunal, pushing forward and interpreting human rights and so on. And she really explained her experience as a female member of this high tribunal in Europe. And so when we talk about gender equality, gender representation in judiciary, of course, we talk about a very important issue, not only at the domestic level, but also at the international level. So I was really shocked by her experience, and I think it's an experience shared, as really highlighted in the report, an experience shared by many female members of judiciary, prosecution office, and so on. So maybe I would like to, in a couple of minutes, I would like to highlight some points of the report and maybe to engage the discussion on this, or three or four points in this outstanding report presented to the General Assembly. The first point that is extremely important, and it's in the report, it's highlighted in the report, is that when we talk about gender equality, when we talk about gender representation in the judiciary, we do not talk only about statistics. We do not talk only about balance between female and men in the bench or in the prosecution office. Actually, we also talk, and it's very well explained in the report, we also talk about substantive equality. And an element that is well detailed and well described in the report is that indeed, when we talk about gender equality, parity in the judiciary, we talk about bringing different voices, different perspectives, also different experiences in the adjudication process. So again, it's not only about respecting the non-discrimination principle in the composition of judiciary, but it's also about discussing substantive equality. And of course, it applies to women, but it applies to all groups, victims of structural, historical discrimination. So the conclusion of the report in relation with underrepresentation of women or stereotypes, prejudice, and so on, applies to, again, all kinds of groups affected by structural discrimination or historical discrimination, as persons with disabilities, LGBT persons, and so on and so forth. And for me, it's really important because it's really about bringing different, as said in the report, bringing different voices, different perspectives, but also bringing different experience as an adjudication body or as a prosecutor and a prosecution body. And interestingly, the report actually raised the question of what adjudication means as a function and why we need actually to have this pluralist composition in order to achieve substantive equality. It's a human function. So it's true that as a human, adjudicating is a human function. So it's true that we also need these different experiences, these different approaches, and so on and so forth. Now, and maybe it's a provocative question, but I would like, but I will explain what I mean. Now, when we talk about gender composition, gender parity, and so on, we also have to raise the question about the consequence of gender composition or gender parity in the bench and feminist judgments. What I mean, and I will give you an example later, what I mean is that it's not enough to achieve gender composition, gender parity or equal composition of a bench, to have a pro-femina or a judgment, focusing on women's rights and so on. I mean, we need more, and it's explained in the report. We need training, we need education to gender rights and women's rights and so on. So, and I think it's a message you sent to the members of the General Assembly. It's not necessarily to achieve from a statistical perspective this 50-50 composition of judiciary or prosecution bodies. It's also important to have education on gender issues, women's rights, and so on, to fully achieve this gender equality and gender parity and substantive equality. But I will go back to this element with a precise illustration taken from the jurisprudence of the Human Rights Committee. The second point I would like to mention that was extremely interested in the report, of course, it's about the challenges and obstacles, and it's very well identified the different types of sociological, but also economic, historical, cultural challenges faced with by many women in many countries, and it's said in the report, it's really a universal trend. And a universal common problem. One of the challenges identified in the report is what also Diego stressed, the glass ceiling, and indeed in many countries, and France is a good example. I think France has not responded to your questionnaire, and I was sad because we would have a lot to say. I have not seen the name of France in the list of states, but in France, I mean, the glass ceiling is a common problem in many countries, including in countries where we have a quite good representation of women. For instance, we have, I take the example of France, we have many female students in law school. I mean, more or less 80% of female students in law school, and only 20% of male. We have also a huge number of women judges and so on. But indeed, when in terms of hierarchy and in terms of senior position, high profile position, we still find, and it's well explained in the report, we still find these obstacles, glass ceiling, and so on and so forth. So it's really a structural problem. And again, and I'm convinced by what you said about quota. I think it's it's an important tool to address this glass ceiling element, because we cannot just be satisfied with statistics and the achievement of gender parity and so on if we do not also address this problem of the absence of women in higher position or senior position in the judiciary or in a prosecutorial position. And I also liked, because it's true at the domestic level, it's true at the international level, I also really appreciate and like what you said about stereotypes in types of field and sectors. And indeed, family matters and so on. And we have, I mean, the same kind of problem at the international level, and for until very recently, for instance, of course, it's not a tribunal as itself, but the CEDAW is a treaty body, quasi-judicial body, we could say. And the CEDAW Committee on Elimination of Discrimination Against Women was almost exclusively composed of women. It's not anymore the situation now, but there is another representation of women, which is not a good thing, because it gives the impression that women's issues are only, or women's violation or women's inequality and so on, are only questions to be addressed by women. Of course, it's anti-universalist approach to human rights. So I think this question of stereotypes and women are more efficient when they deal with a family questions or social questions that when they have to do with economic or financial matters. Of course, it's a stereotype, and we have to, states have to work on this. On challenges and obstacles, and I do not know if it's also, I have not seen things on the report, because maybe it's more a sociological element, but there were also a lot of surveys and studies, especially I take the example in France, explaining that the more we have women in a sector, and the less attractive the sector is. What I mean is that now we have a lot of women in the judiciary, so the judiciary is perceived from a sociological point of view as less attractive, as less interesting, and so on and so forth. So we have also this this relation between the high number of women in the sector and the highest the number are, and I would say the worst, or the worse the picture from outside, or the worse the perception is from a sociological point of view, lack of legitimacy or attractivity of the job. Third point, and I go back to the question of glass, the challenges, glass ceiling, and so on. It was fascinating in the report. There is an important element you mentioned, and I think we have to work on this also. What you call the internalization by girls and women, that indeed they are not, the highest position are not for them, or that they could not be president of the Supreme Court, and so on and so forth. This internalization element is, for me, one of the key issues when we talk about gender equality, gender parity, and so on. And it's really a tricky point, because it's related to education and how to educate not only men, but how to educate girls at a very earliest stage, to educate girls, and then of course women, that they have a place in the judiciary, they have a place in the society, and they are legitimate to share their experience as women, not as men, because we also witness many examples where, you know, to have a place in the society, to have a place in the judiciary, you have to behave like a man. and that's the main message sometimes conveyed by societies, not only in the judiciary, but maybe it's a more general issue or a more general problems. And sometimes this is transmitted by mothers, by grandmothers, and so on and so forth. This idea that girls do not have a place in the society, or should not have high expectation because they are more fitted for, house care, home care, child care, and so on and so forth. So this is a tricky point, because here we do not talk only about discrimination, for instance, discrimination of women caused by men, but we also talk about what we call horizontal discrimination. So sometimes this glass ceiling and so on, this internalization element, of course, it's extremely difficult to perceive, it's totally invisible, but it's really a tricky point, because it's based on discrimination, intrafamilial, for instance, discrimination, or discrimination or conveyed by, again, mothers, female colleagues, and so on. And we have to address this. Maybe it's a taboo, but we have to also to address this. When we the absence sometimes of promotion of female by other females, because we have, as women, we have to keep our position, and so on and so forth. And I just give you an example, and then maybe I finish with the creation of training. I give you an example, and I go back to my first point about gender representation and the absence of automatic link to feminist judgments. Very recently, the Human Rights Committee did adopt views on access to justice for women's victim of massive rapes. And so the decision is public, so I'm not revealing any secret, and it's not confidential. And I was extremely surprised. I was rapporteur of the case. I was extremely surprised because the harshest opposition I received when I proposed to colleagues to conclude to the violation of access to a tribunal and discrimination, because women were not granted proper compensation and so on. The harshest opposition came from women of the committee, and it's written in their dissenting opinion. So that's the reason why, and that's my final point, when we talk about gender equality, gender representation in judiciary and so on, it's an absolutely critical issue, but it cannot go without a proper, and it's also stressed in the report, it cannot go without a proper training about substantive equality. So we have also, as women, to be educated, to be on our own stereotypes when we talk about gender issues, because again, and it's extremely clear that we do not achieve necessarily gender substantive equality without, for men and women, a proper training on what substantive equality means. So I stop there, and thank you very much. I'm sure we will use, the Human Rights Committee will use also these really excellent reports. So thank you for having me in this panel.
Thank you very much, Madam Tikroja, for your presentations. Please, all the participants, feel free now to ask any question to the panelists. I encourage you to do it through the chat in order to better manage the time we have. I already had some questions, and I'm going to ask the first one to the Special Rapporteur, and then I will jump to Madame Tikroja. So this question is for the Special Rapporteur. How political appointments are made and justified by using the gender parity argument? How can we avoid these situations? Please, Mr. Diego García Sayán.
Thank you for the question and congratulations, Helen. I enjoyed your presentation and I fully share your view, your approach. And you are correct. It's France didn't respond to the questionnaire. Unfortunately, it will be very useful to have France approach. But I will use part of what Helen mentioned to respond this question, no? Because it's very dangerous to have a kind of synonymous between a women judge and gender perspective, which is not automatic, because the gender perspective can be in many specific cases, which I know, no, nothing to do with the way in which certain women judges and prosecutors think and perceive the world or the connection with the other persons. No? And there are many men that do have a gender perspective, which is not so. This sexist approach is unfortunately democratic. No? It's not a monopoly of certain men. So women in a judicial position doesn't guarantee by itself. So first, it's a question of general public policies, information that has to do with a general policy in the society as a whole, not an island of gender perspective, which is assumed as automatic if a woman is in the high judicial post. That is not the case. I have, fortunately, my experience in the Inter-American Court of Human Rights with a very few women judges, which I have shared positions there, has been fantastic. No? All of them have had a real gender perspective, and I have enjoyed what that adds and changes certain important decisions, not only procedural aspects, and how that is relevant to influence in the content of judicial decisions. And the second answer to what Jordi asked is in the question, it's a political appointment. So the way to avoid that the gender perspective used as a pretext to appoint a woman that she will be faithful to the political power, and not because she will have necessarily a gender perspective. The way is to stress independence of justice as a whole, which includes proper procedural measures for the selection and appointment of judges, in which all the steps should be taken so to avoid or to limit the political considerations for the selection and appointment of judges. At the end of the day, that has to do with one question. Well, who appoints? If it is the government or the Congress, there will be anyway that kind of political influence. My personal position is not an international standard, of course, is that procedures in which political authorities are directly involved in the selection and appointment of judges should be replaced by others. Council of Magistrates, Conseil de la Magistrature, things like that, in which other society members of the society participate, eventually from the political power as well, but not exclusively. So the selection process should be independent, with participation of the society, in which the society should be informed who is participating in a process of selection, and to have the possibility to give information about that person, to ask questions that the selection committee can eventually ask. So independence in the procedure, general policies, and of course, I think in which we must assume that automatically a woman by itself doesn't sustain a gender perspective. So a woman, yes, but what women should be selected, that's a question which is part of the process that requires real independent mechanism, so that they don't use this as a pretext to control politically the judiciary or the prosecutorial service. So that will be my answer, and I think with this I share fully the view that Helen has just shared with us. Thank you, Jordi.
Thank you very much. I now have one question for Madame Tikurjab. How can the work of the UN Human Rights Committee impact change in how states appoint judges and prosecutors? Thank you very much.
Thank you. Yeah, we have actually, it's one of the main topic where the Human Rights Committee has a long practice and jurisprudence. So in general, very concretely, I mean, there are, the general comment 32 adopted by the Human Rights Committee. So general comment is a kind of advisory opinion. It's not exactly an advisory opinion, but it's a document where there is the consolidated interpretation of the right to a fair trial, Article 14 of the International Covenant on Civil and Political Rights. And of course, we have in this Article 14, it's a long provision, we have some elements on the right to independent and impartial tribunals. So in the general comment 32, there are some criteria and aligned to the international standards, criteria on how to guarantee and to ensure independent appointment of prosecutor and judges. But very concretely also, and maybe it's more concrete on what kind of impact we could have. Very concretely, when we have dialogue with states, so dialogue based on the reports sent by the state, it's systematically a question raised by the Human Rights Committee, very detailed. And we discussed about the diversity of the composition. We have in the membership of the Human Rights Committee, for instance, a judge and a prosecutor. And it's extremely important because when we have dialogue with states, they always ask very, very detailed information on how the state at the domestic level organize this process of appointment and so on and so forth. And of course, based on the dialogue, we then adopt what we call concluding observations, and there's a kind of follow-up process and so on and so forth. So on this element, I have to say that it's really one of the long-standing practice of the Human Rights Committee, and we have more or less the same position as the European Court of Human Rights, the Inter-American Court of Human Rights, and we are extremely concerned by very detailed elements on how it concretely works. So and also we receive a lot of information from civil society. So yeah, I mean, we try to follow this question very seriously on a very concrete basis, I would say.
Thank you very much. We are running a bit out of time, so I'm going to ask one maybe last question for the both of you, for Mr. Diego García Sayane, for Madame Tigrulla. The question is, what changes could be made in post-secondary legal education to encourage more women in the judiciary? I'm going to repeat it. I'm going to send it to you by the chat so you can have it better.
Do you want me to go first, or?
Yes, go first, please, Madame Tigrulla. Go ahead.
It's an excellent question because, yeah, for me, a lot, of course, I'm an academic, so I'm also talking as an academic. It's really, I think it's explained also in the report. We have to, so the question of training is very broad because we have first, of course, to make women realize at this post-secondary stage, realize again that they have a place in the society, they have a place and a role to play in the judiciary, and they may have a high expectation, and it's not bad. So I think in terms of training, it's also important. And it's also important to have women as trainer, because it's also a way to show to young adults that it's possible. So female judges sharing their experience and illustrating their experience and so on and so forth. I think it's one of the key elements. And the other element also highlighted in the report, again, is that women are not dedicated to a pre-established field. I mean, women are not naturally dedicated to family matters, for instance. They could work on financial criminality or cyber criminality, terrorism, and so on. It's not just about family, children matters and so on. And third, and that's my final point, because based on my experience as a member of different committees, it's not a popular position, I would say, or opinion, but we have also to train women to oral examination, oral exams, sometimes because of stereotypes and again, patriarchal society, well detailed in the report. During oral exams, women do not realize that they also try to behave as men, as they suppose that men expect they behave. For instance, and that's really my final point, but for instance, I had the experience as female member of a committee, of a board committee, of women candidates only talking to the male members. So of course, we have to educate women to also this kind of training, and we have to train women to behave in a very equal, especially in this kind of exam process. It's not easy because it's based on, you know, you have to be smiling, you have to be nice, and maybe you have the impression if there is 5 members in a committee and only 1 woman, you have the impression that it's not important to disregard the woman because she's not the important member of the committee, quite the contrary. So yeah, for me, it's also a question of training. Thank you.
Thank you very much, Mr. Garcia Sayan. You have something to add, please.
Thank you. I will follow up with that very clear ideas. That perspective has to do with training in all the process, no? And I would say 2 aspects which are essential. That depends on the way things work in different countries. In some countries, you have to go through the kind of judicial academy before being candidate to be a judge. In other countries, you enter the academy while you are a judge already, so to have a kind of follow superior steps. In any case, I would say that first, in the substantial criteria, in the selection processes for judges and public prosecutors, the gender perspective must be clearly included and considered. And that means not only the substance of the questions or the matters that are being raised, so to prepare a report or an essay or respond a major challenge, no? But in the composition of the bodies. No? So that is very important. And to say that that is part of the public policy. The example that comes to my memory is that when we were I was part of the committee that selected the transitional justice system in Colombia 4 years ago. We made systematic public announcement: women, present yourself, present yourself, present yourself. So the great majority of candidates were women. We didn't have a quota system, but we selected 52% were women, and the president was a woman. So that's a process that has to do with a policy, an approach in which you must create a situation in which women that have a gender perspective feel safe, feel confident that that process is a serious process to this. We have been invited. And really, secondary, we need to strengthen in most countries, no, the gender perspective in the legal education, which is not only learn what treaties have to deal with women's rights, but the gender perspective in how to solve certain problems. And I would give big value to the experience of top-ranking judges from certain courts, from the European Court, from the Inter-American Court, in which, for instance, in the analysis cases and in the reparation process, the gender perspective change dramatically the way in which judicial decisions take place. So I would include that criteria in the selection process. So if a person fails to have a creative and a proper response, even if a person is a woman, she shouldn't be admitted in the judicial. So that's a question in which major things should be done in all these selection committees, whatever the system is in each country. Many things to be done there, but we have enough international standards, we have enough international rules, so we need this real legitimacy to make this clear. So really, that would be my comment. We are almost reaching the end. I have other conference in 2 minutes. So I would finalize thanking very much a lot for this invitation. It's fantastic to have met Professor Ilinti Gruja. I hope that after the pandemic finishes, we can meet personally in Ottawa, in Aix-en-Provence, or in Peru. Nice to meet you. And thank you to Jordi, Salvador, and to all the fantastic people that are participating today in this session. Thank you very much.
Thank you very much, Special Rapporteur. Thank you very much to all. First of all, I would like to apologize because we are not going to be able to answer all the questions as we are running out of time. My sincere apologies. For closing the webinar, I would like to thank the translator and Caroline and give the floor to the director of the Human Rights Clinic at the Human Rights Research and Education Center, Mr. Salvador Herencia. Mr. Herencia, you have the floor. Thank you.
Thank you very much. Muchas gracias, Jordi. Merci beaucoup, Professor Tigruja. Muchas gracias, Diego, for being here with us. And just in 1 minute, to respect everyone's time, I just wanted to say that how we came to this report. The last report to the Human Rights Council focused on the impact of the pandemic. And there we saw how the pandemic was disproportionately, in all levels, affecting women. So we thought that this was under Diego's leadership. We thought that this was a matter that has been largely ignored by the Special Rapporteurship, in addition to UN Women, to the CEDAW and other bodies, and that we needed to pinpoint this situation. Needless to say that with Diego, we have a working relationship for almost 20 years now. I cannot believe that time has gone by so long. Diego, not only that, but as a judge of the Inter-American Court, he usually is very shy to say this. He was a judge in the Cotton Field versus Mexico case. And he was a judge in the Atala Rifo versus Chile case, which was a case of a female judge whose custody of their children were deprived from her because of her sexual orientation. And this is my closing remark. I think that a hidden gem in the report is issues of intersectionality. It's not only that women are underrepresented, but what happens to indigenous women? What happened to ethnic minorities, women with disabilities? Can they be even applied seriously to the bench? So in this case, we cannot only get stuck with neutral norms of access to the public career, because in these cases, neutrality is complicit to continue the systemic discrimination of women. So the next report that we're currently working on is attacks on lawyers. And the issue of women, of lawyers and female lawyers working on sexual reproductive rights, gender equality is and will be present in this report. So I invite all of you to keep following the work of the UNSR, to keep following the work of the UN Human Rights Committee, because our Human Rights Research and Education Center is fully committed to keep working on these matters. And once again, thank you very much for your time, and it's been a pleasure to be here with you today. Thank you. Bye-bye.
Thank you.
Thank you.
Bye-bye.
Bye.